Huls. I'm coming from the Netherlands, and I like to talk about a project that we have embarked upon at the University of Pretoria. I'm a retired professor from the Netherlands, but I'm a young Africanist. I'm now as an honorary at the University of Pretoria Law School, and together with Tjepo Madlingozi, we have taken the plan of writing an introduction for social legal studies for the undergraduate program, and that's what I like to talk about. It has some backgrounds that are familiar with you, but were new for me. This eternal criticism about the quality of legal education, and more importantly, from my point of view, is the empirical approach to law. That could be a bridge between this criticism of practitioners who say these law students, they only have looked in the books, they don't know anything about practice. And one of the promises of sociology of law is, maybe we can offer it via empirical studies of law, training the students to look the empirical dimension of law, which is so sadly missing now in the curriculum. And a third point is the methodology of the social science. In Western Europe, there is a constant debate whether law actually deserves a place at the university. It is not a science, it is more of theology than medicine, so to speak. And so there is a constant need to justify the place. And what I heard from the previous speaker, the same discussion is arising here, that the practitioners, the big law firms, they want to do the training, and I think we should resist that tendency. And so the lawyers that we deliver at the law school should have some knowledge, should even have maybe tried to do some social science. So that's also part of our endeavor. The decolonization of the curriculum, a touchy topic for a white male guy from Holland. So I'm very glad that Tjepo is joining me in this difficult and delicate task. And deliberately, we want to have a place in the LLB. We think sociology of law is not for the happy few, not for the PhD students or the LLM. Every lawyer should have some sense of the social legal dimension and what our discipline has to offer. And let me say because there are many varieties of social legal studies, let me tell you something about how I taught it in the Netherlands, in Rotterdam and in Leiden, and we try to adapt it, of course, to the situation here in South Africa. And there are two main drivers. That is the so-called social production of law. So look at societal forces that have an influence in creating law, not only looking at the traditional sources, but look at politics, look at economic and technological change, the influence of DNA on the criminal procedure. I've been involved in the regulation of gambling. That was completely overhauled when gambling on internet became possible. Those are themes that students like because they know better than the teachers how to use the internet, and it's a good way to demonstrate how hard such changes, societal changes, are for the law to regulate and to follow. How do legal professionals operate? Is it fair to talk about the bar? No. In every country, every society, the bar is extremely diversified. You have the top law firms; they are the most visible one, and many of our students dream to become a partner there, to become a millionaire. And at the other side of the spectrum, we have the legal aid clinics, the social jurists, and of course a large group in the middle. So what kind of professionals do we have? How are they oriented to the needs of the poor or only to paying clients, things like that? That is also very important. Do you have a bar that is open to the needs of the poor, or do you have a bar that is primarily interested in becoming very rich? Last but not least, the legal culture in a certain country. how do people perceive the law? Is it an enemy? Is it someone, some place to look for support? That varies enormously between several layers of the population, and also the legal consciousness of ordinary people is very important. And it is good for law students to get insight in that. So those are societal forces that create the law, that are important how the place of law in a certain society is. But the other side is also important. What are the effects of law? Most doctrinal lawyers are not interested because they say, okay, it's now in the law book, so now we can create a practice around it. That's nice, of course, but we are also interested, how does law come to the people, especially if you have a large illiterate part of the population. I've been teaching in Rwanda for a couple of years. That is also always a problem. How can you tell people that they must obey the law if they are not able to grasp it? How can you make sure that law reaches the people that it's intended? Things like that. And then a nice insight that we should not look at people as atomic individuals. They are always part of organizations, of family networks, all kind of groups that determine how they perceive the law. These groups, they are very strategic. They are mainly interested in their self-interest. It is hard for regulators to make sure that the people really obey the law, because these semi-autonomous social fields have a very important say in how law is molded when it comes to the ground. What do we intend to present in the course? The founding fathers, Marx, Durkheim and Weber. Marx as a conflict perspective on society, Durkheim for a harmony perspective on society, division of labor, things like that. And Weber as the theoretician, as David Trubik reminded us yesterday, of modernization, rationalization of the world. And we will supplement it with relevant African thinkers to make the picture complete. We look in a sociological way as what we call the pillars of a rechtsstaat, of the rule of law. So how do bureaucracies function? How the legislator, how are laws created in the political domain? How do lawyers practice? And last but not least, how is the judiciary functioning? And then not in the verdicts, in the jurisprudence, but how are courts organized? What happens in the courtroom? Look, we invite our students to go to the courtroom and see what happens there. One party is unrepresented and he has a problem with an insurance company who has a complete legal team behind him. What does it mean for equality before the law? What can the judges do? How do lawyers operate? Things like that. So be practical, look at law in action. Third important issue is to be in the middle of the promises of the law and the restrictions of the law. And then this whole idea of transformative constitutionalism is a nice example. It promises a lot, and it's true that it shows that it is not able to deliver on all the promises. And sociology of law has a lot to say about that. What are the limits of law? Is it a good strategy if you want to change society to turn to the law, or are other avenues more effective? Last but not least, you must be, in order to get a place in the curriculum, because we are not yet there, you must be critical, but you must also be constructive. You can say, this course here is too vocational, it is too formalistic, law is only at the wrong side of history, and if you repeat that long enough, they kick you out of the curriculum. So you also have to have a constructive dimension, Okay, we can help you to do better. I think it's better if lawyers know something about social science. Legislators can learn from all kinds of studies how you can make legislation be more effective, all kinds of new ideas about regulation. The legislator is not in the position of only top-down regulation. Sometimes he needs the cooperation of the actors he wants to regulate. Some South African themes that we are discussing at the moment, and I like to have some feedback and suggestions. This idea of top-down legal reform as imposed by the World Bank, rule of law programs versus legal pluralism, more bottom-up. That is a nice topic, I think. The whole idea of intended and unintended consequences of legal interventions. Most of the times the policymaker, the legislators have very wide ideas of the good side of legal interventions, but as sociologists of law, we can tell beforehand that many high hopes in Pretoria or in Cape Town and Joburg, they are dashed in KwaZulu-Natal because legislators have no idea how local practices are receiving the messages from the legislator. Legal consciousness is very important. It has been said by others. Homegrown solutions is also a very nice topic to stimulate students to think about what they can learn from their own practice, from their own environment, not only all kind of important ideas from abroad, and street law is also an important topic. But it is not easy. I'm an optimistic guy, and I have seen the struggles at the law schools in the Netherlands. I see the struggles here. It's fair to admit that the mainstream of the faculty, we don't have many people like Joe Modiri. He's, I think, the exception to the rule. There is a strong tendency against empirical, to get the empirical in. And strangely enough, criminology has tried to get a place in the curriculum in Pretoria, and it was not possible because it's another department. And so there are some serious problems in realizing the plans that we have, but we won't give up the fight. Thank you very much.